available later today. We're ready to hear argument in cause number AP-77-078, Jason Delacerda versus the state of Texas. You may proceed.
Please, the court. I'm Doug Barlow, and I represent Mr. Jason Delacerda, who was sentenced to death in this case for capital murder. Direct my remarks this morning to two issues that are set out in the brief, issues 28 and 29. Those are interrelated issues that deal with ineffective assistance of counsel, and I'll address them together here because they are so interrelated. The issues are twofold. Counsel was ineffective in two respects. One is for first allowing the state's psychiatric expert to examine Mr. Delacerda in the first place, years before the trial during pretrial proceedings. And secondly, the issue in 29 is allowing that illegally obtained evidence, witness to be presented to the jury during the trial. The state mistakenly categorizes these issues globally as strictly a Miranda issue, and I submit that the record is pretty clear that there were no Miranda warnings issued, but the issues are actually much broader than that. Notwithstanding Miranda, which is very important in this case, the state simply had no right to examine Mr. Delacerda in the first place. During pretrial proceedings, there were discussions, I think it's some 5 years before the trial actually began, and counsel for all sides were apparently unaware of the Legron case from this court and the proceedings that had been established for the state's opportunity to examine a defendant for psychiatric evidence. And apparently all of the counsel were unaware of the legal fiction that this court created in Legron back in 1997.
Counsel, I wanted to ask you a question, and I apologize, but given the situation of technical difficulties, I wasn't able to check the record on this. When the initial motion was filed, was there any indication from defense counsel that they were calling a future dangerousness expert?
I think the record is clear that there was no indication that the defense was going to call any expert concerning future dangerousness, and in fact, it's just the opposite. I believe one of the original trial counsel stated to the court that, well, we don't have any psychiatric evidence of it with an expert, and we'd be interested in that also. So we agree to allow the state's expert to examine Mr. Delacerda, and basically we'll see what they come up with. So not only had they not asserted, not only had they not.
I'm sorry, I don't mean to cut you off. I see where you're going. The question that comes to my mind though is, then doesn't that feed into the idea of a strategy on the part of counsel to say, look, we had got any evidence, but we're going to rely on this because it may turn out to be favorable for us. Wouldn't that be something of a strategy?
Well, that is a strategy, but it's certainly not a legitimate strategy. The state offers that in its brief. I submit that there's no plausible reason for the defense to rely on a state expert when the state has no right to examine a defendant just for chance to see if it turned out favorably to the defense. That's the reason the legal fiction was created by this court, is because we have the constitutional protections for defendants so they don't have to submit themselves to that type of investigation or examination for the obvious protections. So I think it's remiss for counsel to say, well, let's let the state do our job and let's see how it turns out. If it's helpful, we'll use it. If it's harmful, and you can very easily make the argument that once the cat's out of the bag, what right do you have to object? If you agree for the state to examine your defendant, then it's evidence in the hands of the state then. So as I said, there's no legitimate trial.
Well, what could trial counsel have done then? What are you suggesting trial counsel should have done in that circumstance? Say that they wanted to get this information and they wanted they didn't have any psychiatric evaluations or anything, but they wanted the information. How should counsel have proceeded? What's wrong with saying, you know what, we want this examination. We can rely on Estelle by saying we want this information, but because we're not presenting any evidence, the state can't present any evidence either.
Well, the defense has the absolute right to seek that type of evidence ex parte. the defense can file an 8 versus Oklahoma claim and say, I would like to
Okay.
have an expert appointed, and then see what the defense expert comes up with. And then if the defense expert is favorable, you may or may not at that time agree to let a state's witness examine your defendant. But at any rate, you're in control of it, and that's what the Constitution provides, and that's what legitimate trial strategy would be you remain in control of it and don't leave it at the behest of the state to uncover evidence that may in fact be harmful to you, and in fact was harmful in this particular case. So I submit there's no legitimate trial tactic to allow the state to do the defense's work for them. The state does exactly that. The state attempts in its brief on page 90 to suggest a plausible strategy. The state says it's just as likely counsel did not object Dr. Doge, that's the state's expert, to Dr. Doge's psychiatric examination of appellant because counsel reasonably believed Dr. Doge would find appellant to constitute no or a minimal risk of future dangerousness, and the defense would therefore be able to use her report testimony to appellant's benefit. And I submit, just as I said, there's no plausible reason to take that particular approach, and it's fraught with danger that appeared in this particular case, came to fruition when the evidence was presented to the jury. It's identical to saying to a client, well, I understand you have exculpatory information. You don't have to tell me about it. You don't have to tell my investigator about it. Let's just let you go give a statement to the district attorney's investigator, and we'll see if it helps. Let's see what comes out when you give your statement to the other side. But in fact, you don't have to do that, and you should not do that. Legron sets out the standard. I won't go into it at length. That it's only when the defense expresses an intent to present evidence of future dangerousness through an expert, then and only then does this fictional waiver of the Fifth Amendment privilege is it created by this court. And actually, it's only when the defense actually presents that evidence is that evidence able to be used. So
can you remind, I'm sorry to interrupt you. I'm wondering, before you get too far away from your comment about the defense expressing an intent, can you remind me, why do we believe that the defense did not express just such an intent?
Well, we believe that because the record absolutely clearly says that. Defense counsel at the time that the pretrial hearings were conducted, when the state filed a motion, they first filed a motion saying we want them examined for sanity and competence. Then they amended that motion and said we wanted to include an examination for future dangerousness. And the defense not only said we don't have any intent, they said we haven't even gotten an expert. We don't know anything about that yet. So let's let the state do it and we'll see how it turns out. So they expressly said we have no intent. We don't know anything about. We haven't examined them for future dangerousness with an expert. So the record clearly sets out that it was at the state's instance that the future dangerousness expert examination was initially conducted in the first place, and the defense simply agreed to it in the absence of any investigation by the defense, clearly stated on the record.
So
Assuming
you don't believe that the agreement to let this go forward shows an intent at all?
No, I don't believe that shows an intent to offer evidence. That's an intent to investigate the case and see if anything comes up that might be helpful. But the proper way to do it is to conduct your own defense examination, not to let the state abrogate the Fifth Amendment privilege that the defendant has in the course of that examination. That's exactly the harm that Legron seeks to avoid.
Well, let's assume for a minute that you do have ineffective assistance of counsel. In light of the rest of the evidence in the case, how do you somehow contend that the second prong of Strickland is met?
I certainly do.
Harmless.
I certainly do. There are a number of cases I've cited in the brief for appellant that set out that a single error can be sufficient to, in fact, I've got it in my note here, a single error is sufficient to establish reversible error in a case that if it's so egregious that it denies appellant a fair trial, basically. And I submit that not only the single error, but the duplicate error, allowing the defense to, allowing the prosecution to examine Mr. Delacerda in the first place and gain that evidence, that single error was reversible error, but it certainly was reversible when that witness was the only expert who then testified at trial to present expert testimony that Mr. Delacerda was considered a higher moderate risk for future danger sufficient to warrant the death penalty.
So the second prong of Strickland is just no longer applicable. Is that what you're saying?
No, it's certainly applicable. It was a failure on the part of defense counsel in allowing it to occur in the first place. It was a failure in defense counsel to allow the testimony to be presented at the time of jury for not objecting on the basis that the evidence was illegally obtained, and the harm accrued when that was the only expert testimony on which the jury could rely from the state or actually the only expert testimony at all that he was constituted a future danger. So I said that certainly.
You mean that? Excuse me. You mean that that the jury can't deduce from all the evidence presented on guilt or innocence that the person is a danger? Is that what you're saying?
They may, and there are cases that say that guilt or innocence evidence is may be sufficient in some cases. But I submit that the harm accrues when you have added to that evidence the expert testimony of the state that was illegally obtained and offered to the jury in support of the death penalty. There's no possible way at this point to gauge, well, exactly what weight was given to that expert testimony, but it was the only expert testimony that the jury heard in assessing the death penalty. And it was obtained and presented in violation of the constitutional privileges that Mr. Delacerda enjoyed. And so I submit that the harm is clear from that. And I submit that meets that.
Counsel, you put on your own expert witness about future dangerousness, right?
I'm sorry, I couldn't quite hear that.
I'm sorry. Didn't the defense put on its own expert witness about future dangerousness?
Well, the defense ultimately did present Dr. Grapan in rebuttal to the state's evidence that the state put on. But I submit that even if the defense had presented Dr. Grapan in its case in chief, which I don't believe under the record he did, I believe the expert testimony was offered only in rebuttal to the state's expert that was illegally obtained. I submit that the state's expert her testimony was not even admissible as rebuttal testimony because it was illegally obtained. It was obtained in violation of Mr. Delacerda's Fifth Amendment privilege against self-incrimination and giving a statement in the first place. And additionally, more importantly about that, this is where the Miranda issue comes back around in play, is that the record is pretty clear that no warnings were given, that he was not warned, that Estelle versus Smith clearly sets out that defendant has to be warned ahead of time that his statements can be used, of course, against him. All those lengthy warnings, there's nothing in the record that indicates that he was warned. In fact, the record implies, and the witness testified to everything she did, and noticeably absent is any warnings. So even if the defense
was she specifically asked about the warnings? I mean, you say the record doesn't show that there were warnings. Does it show that there weren't?
Well, that's arguable whether it shows that it weren't, that the warnings were not given. Nobody specifically, as the state pointed out, asked her, did you give the warnings? Frankly, because none of the lawyers made an issue of it whatsoever. They basically waived all that, and nobody asked her. And so, but the record I submit is clear that she was asked, what did you specifically do? As I recall from the testimony, what did you specifically do? And she set out what she did, and absent is any indication of warnings. There's no indication of warnings that are normally set out in other statements that are admitted by psychiatric mental health experts or by police officers. It's completely absent in this case. And if we waited, so I submit that the record is sufficient to establish the ineffective assistance of counsel, but we could wait a year or two from now and at a subsequent written hearing, ask her the question, did you give warnings? And she says no, and it would be reversed then, I submit, because that evidence is simply not admissible for any purpose. And the record is sufficient.
I see I'm sorry. I'm sorry to interrupt. I see that you're running out of time, and I wanted to sort of follow up something on something that Judge Keller asked, Presiding Judge Keller asked, which is there was a defense expert on future dangerousness. As I understand Legrone, the idea is that you allow for the examination when there's a reason to believe that there's going to be some sort of examination that the defense is going to use. I mean, if we go with your ruling, aren't we going to be then saying that all the defense has to do is get their future dangerous expert and then see if the state introduces their future dangerous expert and then say, we presented it on rebuttal? I guess what I'm saying is, isn't your argument really just sort of coming down to a matter of timing? I mean, it seems like
No.
everyone from the record knew that this was going to be there's going to be evidence on future dangers from experts. So,
well, I submit that the record does not establish that. The record established that there was no indication. In fact, there were statements to the contrary of whether future dangerousness experts would be presented. Defense counsel 5 years before trial said, we don't have any expert. We haven't looked into it. Let's let the state examine them and see how that turns out. And so no, there was.
Counsel, I can't hear you.
I'm sorry. I understood what you were saying. I do understand what you're saying. My point is though that even if the argument, there was no indication at the time the examination was done, by the time we get closer to trial, don't we sort of know now that trial counsel is going to be calling a future dangerous?
I don't think I saw anything in the record that indicates that that defense intended to do that. And if they did it in rebuttal. And additionally, the evidence was inadmissible for all purposes. There's no indication that he was warned whatsoever about his constitutional right not to participate in that type of examination. And that evidence could have been excluded. It may have resulted in Dr. Grappon's testimony being excluded if they had offered it in the case in chief. But I submit it was not admissible for any purpose whatsoever.
Counsel, were you going to reserve some of your time for rebuttal?
I did reserve some time.
Are you reserving? Okay, well, you're running in, so I'm going to.
Okay, well, I conclude my remarks and I'll await further remarks if necessary.
Thank you.
May it please the court, Michelle Townsend for the state of Texas, Hardin County. I'm going to pick up where Judge Newell left off with his question and Mr. Barlow was replying about the state of the record. I would disagree. If you look in Reporter's Record, Volume 6, specifically pages 10, 12, and 16, you'll see that they state, Mr. Delacerda's defense team states they have no expert as to competency, but they do indicate that they are talking to some doctors and waiting for some reports. Those are direct quotations out of the record, and that they are going to have an expert on future dangerousness, quote, depending on what Dr. Duget, I'm not sure how to pronounce her name, what she says. So at the record or at the hearing where the order is signed, there's the indication to introduce evidence through psychiatric testimony on the issue of future dangerousness. So at that point in time, Soria, Legrone, Chamberlain gets triggered, and there's that constructive waiver of Fifth Amendment right to remain silent, meaning that when she examined him, it was, you know, they all agreed actually too. Whereas
Counsel,
yes,
I wanted to ask you, given our thing for Legrone, our holding in Legrone, that's something that we came up with, the legal fiction that we came up with. The Supreme Court has recognized that that the state can introduce some of this expert stuff that has gone on independently. I want to say it was like Kansas versus Cheever was one of the cases, but Legrone is the one where we have specifically said, in anticipation of something, you can then require the defendant to undergo an examination. That is us. That's not something that the Supreme Court has said. Is that correct?
agree. The U.S. Supreme Court?
Yeah,
Yes.
the U.S. Supreme Court.
Yes. Let me see. If you look in Estelle, though, I do believe there's language there that leaves that open. because it talks about, pardon me, evidence or intent to introduce such evidence. And that is in the defendant's brief, actually, one of the quotations that he pulls. So moving on through, that's where you kind of have to parse out in the record whether he's talking about an intent to introduce psychiatric testimony on the issue of competency, which he plainly says he's not, or whether he's intending to introduce psychiatric testimony on the issue of future dangerousness, which he says he is at the hearing on, I believe it's January 10th, when this order is signed, allowing her to do her second examination. To the point that the record does not establish warnings were given, it also doesn't establish that they were not. And that's what puts this court in a difficult position on an ineffectiveness claim on direct appeal. It can't be decided with speculation. It can't be decided on a silent record when it doesn't say whether or not he was given warning. So if you want to take the tack that Mr. Barlow invites, where the silent record means warnings weren't given, we can't do that now on direct appeal. Although I would submit that the plausible trial strategies that I presented in my brief are indeed reasonable trial strategies. And to the extent the record indicates any kind of trial strategy on the part of trial counsel, that's what they indicated their strategy was. Because I would disagree with the characterization as a state's expert. She wasn't really a state-sponsored expert until the state put her on the stand. She was a court-ordered expert that the parties actually agreed on. If you look at Reporter's Record 5, page 6, and then Reporter's Record 6, page 10, they actually suggest her name and agree on her as a psychiatric expert.
But I guess I would quibble with you on that in the sense that she is the expert that the court is ordering the defendant to go to the examination for. And I think that's the reason where we're getting into the state action, is that this defendant, while he may have suggested the name, this isn't his own independent expert. This is something where he has specifically been forced to undergo this examination. So I do kind of see counsel's point in that regard.
Which is a fair statement. And to counter that, he, in that same, almost that same breath, indicates his intent. I mean, on the very next page of the record, he talks about how he's talked to doctors and he's waiting on reports.
So just to clarify, these record references you've given us, your position is that the trial attorney actually stated, I'm not going to call or consult with an expert on future dangerousness. I'm waiting to see what the state comes up with to decide that issue?
I would characterize it as him saying, I'm not going to seek any further doctors until I hear what the court-ordered doctor says, indicating that he may have believed she would offer an opinion that said he was a moderate to low or low risk of future dangerousness, and would then be able to take that opinion and testimony and run, and the state would be in the position of, I guess, trying to find a different doctor to examine him to come up with whatever they wanted it to be. But I mean, that's an issue that's not presented in this case, so we don't need to go down that rabbit hole. I would submit that.
I would like to just clarify, because you're saying that this expert was a court-appointed expert, which would, at least to me, it distinguishes that expert from what we would consider a state expert. So can you illuminate for me whether this expert was somebody who was recommended by the state for the purpose of providing state support in the prosecution, or whether it was instead a sort of neutral court-appointed expert?
To me, from the record that we have, I see it as a neutral court-appointed expert. The state did not suggest her. I believe it was actually the court, the judge.
But the state filed a motion requesting appointment of an expert, right?
The state filed a motion requesting that the expert who had already been appointed for competency and sanity re-examine the defendant for future dangerousness.
Well, we can all agree, though, that this was not someone the defense asked for. So whether it's the state or the judge, it's not on the request of the defense.
Correct. The defense did not name her and request that she examine the defendant.
Counsel, I'm sorry. One of the things that I wanted to ask, or sort of ask generally about Legron, given that this is our own precedent. The idea, as I understand Legron, is that we can, that the state is entitled to require an examination of the defendant in anticipation where there's some indication the defendant intends to offer their own psychiatric or their own expert testimony. So my question is, what do we look at? How are we supposed to determine whether there is that plan? Do we limit it to the moment of the motion? Do we look at the entire record all the way up to the point of the trial? Does it have to be a particular statement, or is it just something that we can sort of piece together looking at the entire record?
We look at it at the point the trial judge issued the order. We don't get to look back with the benefit of hindsight. We look at what was in front of the court at the time it made the order. And at the time the court signed the order, again, you had pages 10, 12, and 16, where counsel had clearly indicated that he was speaking to some psychiatric experts and he was going to have an expert on future dangerousness. When I make my arguments that it wasn't deficient performance and he wasn't prejudiced anyway, you can see that later he does seek actually two different psychiatric experts, Hamza and then Ripan, who ultimately testified. And at that point in time, that would have triggered it, which is why he can't establish both prongs of an ineffectiveness claim. So I would submit that what occurs at the hearing indicates that it's not deficient performance. And even if we move past that, he can't establish prejudice because the state would have been allowed to request their own examination at those point in time, either June 2013, when he indicated the intent by filing that notice of experts that listed Hamza, or when he filed his notice at trial. And then
But you'd also add the actual facts of the case to the prejudice prong, correct?
absolutely. Absolutely. That's king. And that's in my brief, where just the sheer brutality of the crime establishes that the outcome on future dangerousness, the jury's issue on that, or the jury's answer on that issue, the state would submit would not have changed. I made notes and I tried to respond to all of counsel's points. I mean, I don't want to reread my brief for you. There's not much more that I would add. There's not really any more that I would add after my responses to counsel's argument and then what the state, what I put in my brief. But I am happy to answer any questions that any judge has.
It's not just that we're all on mute.
Appreciate your presentation.
Okay. If there are no other questions, then I would respectfully request affirmance of the conviction and sentence and give back the court the remainder of my time in the interest of judicial economy.
Thank you, counsel. You may proceed when you're ready.
This is Doug Barlow. I do have some brief remarks I'd like to make if this is the appropriate time.
Yes, sir.
Oh, okay. I just have several remarks that I'd like to make in response. First of all, the facts as the state would have it simply kind of turn the Legrone case on its ear. Under Legrone, an indication that you are investigating a case and consulting experts is not the same as indicating an intent to offer evidence. What triggers the right to for the state, this legal fiction, to abrogate the Fifth Amendment privileges when the defense says we intend to offer evidence of future dangerousness. Then the state has the right to rebut that or examine evidence to see if they can rebut that. It's not a fishing expedition where if the defense says, well, we have some experts we're consulting, so then they suddenly have a right to have experts to examine the defendant and violate his Fifth Amendment privileges. That's not the way what Legrone holds and not the way it works. It's only when that express intent occurs, and I submit that that did not occur in this case. The fact that defense may have been consulting a dozen experts is not the same as saying we have intent to offer evidence, and therefore you have a right to investigate and rebut that, because it would be unfair for us to have evidence that we've gained through conversations with the defendant and the state be shackled and not have that same opportunity. That's what the Legrone principle holds, and we didn't approach that at all in this. Yes.
Mr. Barlow?
Yes.
As I understand Legrone, it was a case talking about this using a state's expert under certain circumstances. And counsel for the defense has suggested that, in fact, this was a neutral court-appointed expert. And so I'm wondering if you could shed your what you believe about that, some light on that for us.
Okay, I don't think there's a case that says that there's a right by the state to have any expert appointed by the state, by the court, to violate a defendant's Fifth Amendment privilege against testifying simply because the defense is conducting an investigation. And as previous judge mentioned, it's not.
Excuse me, is it your position that at that hearing, the defense made no mention of future dangerousness at all? Because I'm curious if they did, and you're talking about experts, it's not a huge jump to consider the fact that they may be talking to these experts for the purpose of putting on evidence.
Well, that may very well be the case, but that's not what Legrone holds. Legrone, the fact that you're talking to experts is not in any sense an intent to present expert testimony. Many cases that I've tried, of course, we consult experts, and if an expert is not helpful to you, then you don't present that evidence and you haven't expressed an intent. That doesn't trigger the state's right to examine your defense, to examine your defendant just because you are conducting an examination into specifically saying I'm conducting an investigation into future dangerousness. That's not the same as saying I intend to present this evidence, and that doesn't trigger the state's right then to examine the defendant and gain evidence in violation of the Fifth Amendment privilege. And this also all stems in with the lack of warnings that I agree that nobody specifically asked this expert, but I think the record is fairly clear that she set out, she was asked specifically, what did you do? Noticeably absence is any mention of any warnings whatsoever. And I think the Estelle case specifically said to meet its burden in that case, the state used respondent's own statements unwittingly made without an awareness that he was assisting the state's effort to obtain the death penalty. That's what occurred in this particular case. And the fact that when counsel mentions that, well, the defendant agreed to this back at the pretrial hearings, agreed to a court-appointed expert, that's part of the harm also. That's not effective assistance of counsel to agree to someone who is not protected by the ex parte rights that a defendant has to conduct ex parte proceedings. A defendant has a right to conduct all of these proceedings ex parte, and that is waived only when the defense reaches the decision that we are now going to offer evidence. That wasn't even approached in this case.
Counsel, I believe your time is up.
Okay. Thank you. That concludes
time
my
is up.
remarks. Thank you.
Thank you very much. The case is submitted. The court standing.